Our next speaker is Robert Cole, Professor of Law Emeritus at Berkeley Law. And I have to admit, Bob, you've made me think differently about lawyers in my 6 months or so co-organizing with you.
You're better or worse?
Well, much better.
You've made me think differently about family therapists.
Oh, wonderful. He's amiable and gracious. But there's a term from Athenian or Periclean Athens that really apply to you, Bob. It's in Greek, I think, I'll mangle it in Greek, but sophrosune, which is sweet reasonableness. And I really think that is a character that I would hope lawyers will gain from your exposure to you at this law school. So Robert Cole will speak on ethics, advice, and government lawyers.
Well, very few of us are likely to give legal advice to the White House, let alone on issues of detention and interrogation. But I think we can draw some ethical lessons from the advice that was given, and that ethical advice is useful to us, to lawyers and to law students, and I hope actually to the general public. Whenever we are confronted with a situation where the client is impassioned and demanding, and the stakes, as they are in these torture memos, are very, very high, and the pressure is just super high. And those were the conditions, to some extent at least, in which these OLC memos were written. You've heard enough about them. The Office of Legal Counsel is an office in the Department of Justice which has a kind of a dual mission. They're actually a little bit like judge advocates in the military. Their dual mission is, of course, to do client service. They have to give advice to clients. But they are also supposed to be a disinterested, apolitical, and judicious office that issues opinion letters that are in fact treated as law within the executive branch. And so they combine, the office is supposed to always have a disinterested quality in its work. And of course it's traditionally or often been a very high quality office. So the two memos that dealt with torture and which basically defined torture so narrowly as to do away with it as a problem, were written in 2002 and 2003, and they were withdrawn by OLC in 2004 because they, first of all, on grounds of incompetence, but also on grounds that they did not meet the mission of the office. That is, they weren't disinterested. They were advocacy pieces rather than disinterested memos that could function as law within the executive branch. Then, as you've heard, after the memos were withdrawn, the Office of Professional Responsibility investigated. They found a rather stunning conclusion that the memos represented intentional professional misconduct on the part of one author and recklessness on the part of the other. They recommended that they be referred to their relevant bar associations, and as you heard, that was overruled by the official to whom who oversees OPR, and who said that, well, it was bad judgment or poor judgment, but that was the end of it. Now, what I'd like to talk about are not the rules of professional ethics, but ethics, that is, classical ideas of ethics as constraints that one imposes on oneself out of duty or a sense of rightness. And to see, and what my point is going to be is that if you make an analysis of from an ethical point of view of the situation in which these memos were written, you come out, I come out at least, with a conclusion that they were ethically required to write a different kind of legal advice. They were ethically required to write a different kind of legal advice. And I'm going to say the various reasons why I think this is true and say what I think the memo should have looked like, and except unless I mention otherwise, you can assume that OLC did nothing of the kind that I'm talking about. I want to start with the moral evil of torture, cruelty, coercion, coerced confessions, extended detention, as I see it, and that is that what you're doing is what's being done is that a sentient thinking subject, a person, is being treated as an object. And he's being treated as an object by his captor for the instrumental benefit, the instrumental use of the captor. In other words, he's being treated as a means for the captor to obtain information or to punish or to just have fun. And in doing this, the captor also violates the basic premise of personhood, which is that persons are equal, by preferring himself and his interests and treating the captive basically as subordinate or less of a person. In other words, I can inflict as much pain on you as I want to because it is useful to me. And I don't have to care about you or your pain because you are a thing. That's the essential evil. Now, that evil, the denial of personhood, goes to the starting points of the ethical systems that we use. Whether our ethical systems are derived from religion or from natural law or from a Kantian type of analysis or even eventually from a social contract point of view, they have to, any ethical theory has to start by positing something, some value to start the system. No ethical system is self-contained and self-sufficient. You have to have some outside value that you just posit to start the system. And personhood is the one that our ethical systems posit. So, so when you do not just torture or cruelty, but various actions along this spectrum of cruelty and coercion that I started with, when you do this, you are in some way violating personhood. You fall into that model I just mentioned. And the problem is that, or the fact is that to make an ethical system coherent, if it starts with a principle like personhood, it has to be inviolable. If you say, well, personhood is usually inviolable, but then there's sometimes when you have to ignore it. Well, then your ethical system then when you have to go one step further and have a criterion as to when you can violate personhood and when you can't. And that then becomes a new ethical theory. That is an infinite regress unless you stop with the values that you posit to start the system and make them inviolable. If you don't, that's not your ethical system. You have to go back. But whatever system you end up with has to start with a value that you can't compromise. And in our system, it's personhood. This is also the starting value of our legal system. We conceptualize, in my view, our legal system starts with the assumption of an autonomous, free, equal, pre-political individual who can be actualized as a person, as a human being, and whose values of whose bodily integrity are protected. But it's that autonomous decision maker that's the core of it, of the notion, and that also is under our legal system. That core person is inviolable, and all of them are equal. They have to be, or the system becomes incoherent. Now, you can't have a totally inviolable personhood in the sense that we all make use of each other. All of our transactions out in the public world, society requires that people be used as means. But as Kant said, the point is you can't use a person only as a means. You have also to treat him as an end.